Hello, my name is Isaac Sturgill, and I'm a housing attorney with Legal Aid of North Carolina. I represent tenants in eviction court. Today, I want to talk to you about a complaint that a tenant can use to file against a landlord when the landlord is not making repairs that the tenant needs to be made at the home. This would be a case that the tenant would file against the landlord, where the tenant would be the one suing the landlord. This is not a form you would use if you were being sued by your landlord. So this is something where the tenant is the plaintiff or the tenant is the one filing the lawsuit. Um, so I'd like to start by just giving a disclaimer. This is not legal advice, and nothing in this video should be considered legal advice. For people watching this, I don't know the details of your case. I'm not telling you should use this form to sue your landlord or you should not do that. So again, this is not advice. This is just information. But I am going to give you some helpful information and kind of walk through the form to show what it's used for and how tenants can use it to sue their landlord if the landlord is failing to make repairs. But the ultimate decision of whether to file this form is on the tenant watching this video. And I would encourage anybody that's considering filing a lawsuit to try to speak with an attorney about their legal rights before doing so. Another thing I wanted to say is that, again, the purpose of this is to file a lawsuit against a landlord who's failing to make repairs that are needed in the home. And just briefly, in North Carolina, landlords have a duty to make repairs. So if a tenant tells the landlord about a problem that needs to be repaired, the landlord has a legal obligation to fix that problem. And that's true no matter what the lease says. And if a landlord fails to fix a problem in a home, this could be anything from a broken water heater to no furnace during the wintertime, leaky pipes. It could be a lot of different things. But if the landlord fails to fix the problem and the tenant keeps paying the rent and during the time the problem's there, and if the tenant has told the landlord about it, but the landlord's just refusing to do anything about it, the tenant may be entitled to some compensation from the landlord, and that's what we call rent abatement. And what that essentially is the tenant asking the court to make the landlord give the tenant some of the money of the rent back that the tenant has paid the landlord. The last thing I want to say before I get started here is there's two parts to this training. So the first part is this part where we're going to look over the form, we're going to talk about it. The second part is deals with some other paperwork that will be helpful for a tenant that's going to file the lawsuit, as far as a form to get the filing fee waived if the tenant qualifies. And also we're going to talk about the summons, which is another document. So we're going to go ahead and get started now and jump right into part one. And I'm going to pull up on my screen the form so we can look at it together. So this is the first form, and this is what we call a complaint. And so again, this is not a situation where a tenant has already been sued and maybe they're in an eviction proceeding or the tenant has a lawsuit that's already been filed against them. This is where the tenant is making the first move. So there's no lawsuit pending yet, but the tenant wants to start a lawsuit against the landlord. And so that's what this document is for. The first part of the document is called a case caption. This is just information to identify the case for the court. And so the first thing the tenant would do is just fill in the county. So, you know, whatever county in North Carolina the tenant lives in, they would fill that part out. Then the tenant's going to put the names of the parties. So in this situation, because the tenant is the one filing the lawsuit, the tenant is the plaintiff. So the tenant's going to put their name right there over plaintiff. And then the two spaces here are the names for the landlord. So the landlord would be the defendant in this situation. And there's two spaces here. And the reason why the form has two spaces is because both landlords and property managers are responsible for making sure that these repairs are made, and that they both could be liable in a situation where neither one of them is doing anything to fix the property. So some landlords manage their own properties. So in that case, there may only be one defendant, but sometimes you have a landlord and a separate company that is a property manager. And so in that situation, you would use, you know, you could put both the landlord and the property manager. Another important thing to look at is making sure that if someone's going to sue a company, so if the title is if the property is owned by like a corporation or an LLC or something like that, the tenant wants to make sure that they're actually using the company's legal name in the lawsuit and not like a trade name or something like that. So a lot of times, I'm just going to make up an example. You may have like ABC Corporation or ABC Company LLC or something like that. That may be the legal name, but the name that they actually use in business may be something different. A couple ways you can check that. One, you can look at the on the Register of Deeds website online and search for the property. That should bring up who the owner is, and it should be the person's legal name. You can also search on the North Carolina Secretary of State's website. There's a business search or a corporation search tool on there where you can type in the name of the company and see if you can find the legal name for the company. But that is important. Up in the right-hand corner, this is where the file number would be written. And so if you're going to fill out this form and if you want to file it, you're not going to know the file number until you go to file it, because the clerk will give a file number to it once it gets filed. And so for right now, that would just be left blank. And then in the upper right-hand part too, you'll see it says District Court Division Small Claims. Small Claims Court is a part of the district court system that handles cases that go up to a certain amount. So in some counties, the maximum amount you can sue for in small claims is $5,000, and other counties the maximum amount is $10,000. So the reason small claims court is maybe a better place to do this, even though there is a maximum amount of money that you can get through the lawsuit if you win, is because small claims court is typically less formal and a little bit easier to navigate than district court. I will say, however, if someone wanted to file this claim and they were okay going in the district court without a lawyer, they could cross out the small claims part and just file it directly in district court. In that situation, there would not be a limit on how much the tenant could sue for, but it's going to be a little more formal and a little more difficult to navigate. It's actually really common for people to not have attorneys in small claims court, but in district court, it's more common for people to have lawyers representing them. So moving down, we're going to go into the allegations now. These are the factual statements that the tenant would be making in the complaint to make their lawsuit. The tenant's going to put the resident of whatever county that they're in, the defendant 1 and defendant 2. So remember, defendant 1 may be the landlord, defendant 2 may be the property manager. You're going to put what county they reside in or they do business in. And then here, this is just saying that we're from now on throughout the rest of this form, we're going to call both the landlord and the property manager. If you have 2 defendants, we're just going to call them both landlords. So that just makes it easier to read moving forward. Here's a space on paragraph 5 for the tenant to put the address of the property that's at issue. And so that's where you put the address of the home that you were renting in there. And then this is explaining the relationship of the defendant, whether they're the owner or the property manager. So whoever you wrote down as defendant 1, you're going to check either that they own the property or that they're the property manager. And they could be both, right? If you have a landlord that manages his own property, you could check 1 and 2, that defendant 1 is the property manager and the owner. If you have 2 defendants, then you do the same thing for defendant 2. You're just explaining to the court what that person's role is. And then we get to our first claim for relief. And so the first claim for relief, the legal term for a landlord failing to make repairs is breach of the implied warranty of habitability. That's just, that's some legalese, but that's what the actual legal claim is called. And now we're going to give some more information on what happened at the property. So we're going to put the date that the tenant moved on into the property. If the tenant's already moved out of the property, you would put the date that the tenant moved out. But many times the tenant may still be living in the property, and so you would write, not applicable if that's the case. Listing the rate of rent for the property is important. So, you're going to put how much it is, whether that's monthly or weekly. So let's say it could be $1,000 per month, or it could be, $200 per week. But it's important to let the court know how much the rent is, because what this claim is asking is for the court to make the landlord give some of that rent back. And here's where we get to what the landlord did wrong, or what the tenant is alleging that the landlord did wrong on this form. And there's several boxes to check here. It could be possible that more than one box applies. But the first one is maybe the most common, is just that the landlord has failed to make the repairs necessary to put and keep the rental property in a safe, fit, and habitable condition. And again, that could be anything there's a lot of things that can make a place not considered safe and fit. It could be, leaky pipes. It could be mold. It could be no heat. It could be if it's really hot, the AC going out in the summertime. So that could be a number of different things. The next one says the landlord has not kept the common areas in a safe condition. So landlords also have a duty to keep common areas in a safe condition. And this would be a situation like if the tenant lived in an apartment complex, or maybe even a duplex or something. The common areas like the hallways and the lobby and all that kind of stuff have to be kept in a safe condition. So that one's not as common, but it is another requirement under the law. This one says the landlord has failed to keep the property in compliance with the local housing code. So in addition to having to keep the place fit and habitable, if the tenant lives in a city or a county where they have a housing code, not all of them do, and the landlord has violated that housing code, or they haven't kept their property, up to code, as we say, that's also a violation of the law. And then finally, the landlord has not promptly repaired all electrical, plumbing, sanitary, heating, ventilating, air conditioning, or other facilities and appliances that were supplied. So that's one where, part of the law too is that if the landlord supplies appliances like a refrigerator or a stove or anything like that, they have to make sure it stays in good condition. Then there's a box that says other. So if it's something that you think doesn't fit into any of these other categories, that's a place to check that box and then write in what the landlord did wrong with respect to the repairs. Again, we're just saying the landlord may have done other things that were wrong besides not kept the place in good repair, right? But this is really just focusing on the landlord failing to make repairs. I think this part is important. So you want to actually list some of the, list the conditions that the landlord didn't repair. And the reason that's important is because what this form does, it starts the lawsuit, but the landlord has a right to know, what the allegations are against them, or, what exactly it is that the tenant is saying they did wrong. And so it is a good idea to list those things here. And it could be more than one thing. It could be leaky pipes. It could be no heat during the wintertime. It could be a number of things, but you want to list those things here. You don't have to go into a ton of detail here, but you need to at least give the landlord an idea about what the issues are that you're complaining about. Going on to the next section. So that's just establishing what the bad conditions were. The next section talks about how the tenant gave the landlord notice about the problems. Because for the landlord to be found liable, the tenant does need to show that the landlord was on notice that these bad issues existed. So there's a few. One, the repairs were needed when I moved in. If they've existed there the entire time you've been there, it's assumed that the landlord knew about them, because they were in possession of the property before they gave the keys over to the tenant. I told the landlord that repairs were needed. So this would be something if the tenant, had a conversation over the phone or in person with the landlord, they could check that box. And that is considered sufficient notice. You can give verbal notice. Is that a good idea? It's not ideal, because if someone gives verbal notice, like over the phone or something, and then the landlord later just disputes that or says, no, you never told me that, the tenant doesn't have any proof. The better option usually is for the tenant to give written notice. And that could be like text, an email, a letter, any of those things. And so the reason, again, why written notice is better is because it makes a record. And then that way, if the landlord says they didn't get it, the tenant has something they can show to the court to prove that notice was given. The next one is if a tenant calls and gets a code inspection done from a county or a city code inspector, usually the inspector will write up a inspection report and then send a copy of it to the landlord. So if that happened, that's another way the landlord could have gotten notice. That's not really notice from the tenant, but it's notice from the city or the county that the landlord's property is out of compliance. And I would say for a tenant that's going to check that box, if the tenant has a copy of that report, you can go ahead and attach it to this form before it's filed. And then there's another box for other. So if there's some other way that the tenant let the landlord know about the problem, that's where they would put that. The next part is talking about how much money the tenant thinks they're entitled to get back. And the way that the court will decide that is that the tenant is allowed to give his or her opinion about how much the property would have been worth if it was in good condition, so if there weren't any problems, and how much they think the property was actually worth with all the problems that were there. And there's no magic formula for this. There's no law that says like a broken toilet is worth $50 of rent back a month or anything like that. It's really just based on people's opinions. And if the tenant is entitled to give their opinion, if the judge disagrees with that opinion, the judge can make up their own numbers there. But I'll give you an example. So let's say I have a case where I had a really bad infestation of mice, right? And it's been going on for a while. And let's say I agreed to pay, $1,200 a month for rent. So in here, on 15, in my opinion, of if the rental premises was in good condition and did not need any repairs, a fair rate of rent would be, I would probably say what I agreed to pay for in the lease, right? $1,200 a month. But if you think it actually would be worth more than that, you can give your opinion. You can make the number more than that. But again, that's the property in good condition. And then going up here, on 14, in my opinion, a fair market rate of rent for the property was only, let's say, I think because of this mice problem I had to deal with for so long, I think that even though I agreed to pay $1,200, it's only worth, in my opinion, $900, right? So I could put $900 per month because the landlord failed to fix that problem. And so in that example, if the court grants the claim, they would take the difference between those two numbers, the $1,400 and the $900, which if they accept my opinion. And for every month where I paid the rent and that mice infestation existed, the court could give me back the difference between those numbers. So in that case, it would be $500 a month. That's just an example. And again, the court has a lot of discretion here. So if the court, wants to make the number higher or lower, they have authority to do that. It's also important for the tenant to tell the court how much rent they actually paid there. So this says 16, I paid my rent to the landlord from at least this date to that date. Maybe the tenant's been paying the rent the whole time. Maybe the tenant hasn't paid for the last couple months, but paid for 8 months before that. It's just important for the court to know, when you started paying rent and when you stopped paying rent. Because again, you can only get money back for the months where you paid the rent, right? If you're living in a property, typically if a tenant's living in a property but is not paying rent and there's problems, the amount the tenant can get back is limited to how much they actually paid. The rest of this, excuse me, are not parts that the tenant would need to fill in. This is just setting up the legal claim. And this is kind of the legalese or the legal terminology to make the claim. So saying, the landlord breached the implied warranty of habitability. It cites the statute. It says that the tenant's entitled to what we just talked about, the difference between what the property would have been worth if it was in good condition and what the property was actually worth, considering all the bad repair issues there. So it's asking for that money back, and it's also asking for in the order that the court lower the rate of rent until the property's fixed. So the court does have authority to do that. If the court grants the claim, they may not only make the landlord give the tenant money back, they may also tell the landlord, you're only allowed to charge, X amount of dollars a month until all the repairs are made. Another type of damages that a tenant can claim in these situations are what we call out-of-pocket expenses. And this means, like, if the tenant had to spend any money out of their own pocket to fix something that they told the landlord about, but the landlord failed to repair, this would be a place to do that. So I'll give you an example, going back to the example about the mice infestation. Maybe the landlord never sent anybody to get rid of the mice, and so maybe I had to buy a bunch of mouse traps, right, and set them all over the house. And let's say I spent like $50 doing that. I could and this part say I also want to be paid back for those mouse traps, because I should have never had to buy them in the first place, because it wasn't my responsibility to fix the problem. So on here, you would list what the actual items are that that the tenant had to pay for, and then how much they cost. So that's just a place to list those expenses. So that does it for the first claim. There's a second claim for relief here, and that's the unfair, deceptive acts or practices law. And so this is a separate law that says it's illegal for a landlord to use unfair or deceptive acts while renting a home to a tenant. And that's a consumer protection law. It doesn't just apply to landlords, but landlords are included in that. And there's really good case law in North Carolina that says that if a landlord is continuing to take someone's rent, but they're refusing to fix bad conditions on a property that are not the tenant's fault, and that again the tenant has told them about, that's not only breaking the first law we talked about, it's also breaking this unfair and deceptive acts or practices law. And why is that important? The importance is, by bringing this claim, the tenant may be able to get a bigger judgment against the landlord, because if the court grants this claim as well as the first claim, the court can triple, or they call it trebling, but triple the amount of damages. So if under the first claim I was entitled to $500 of rent back from the landlord, if the court grants this claim too, it would go from 500 to 3 times that amount, 1,500. So it's a very powerful tool, and in most cases, again, if the landlord fails to make repairs, it violates this law. And we have some good case law on that. So if the tenant wants to bring this claim too, they would need to check that box up there next to second claim for relief. 21, there's a blank to put in whatever county that you live in. It's just saying the landlord is renting homes to people in that county. And then the rest of it is just setting up the damages. It quotes the statute there. It says the tenant was harmed, and they should get triple the amount of the actual damages that they have. Getting very close to the end on this now. The last part is really important though, and it's the prayer for relief. It's asking for the court to give the tenant damages for the claims against the landlord, reduce the rent to a lower amount until the repairs are made, charge the cost of the case to the landlord, and give the tenant anything else that the judge may think the tenant's entitled to. So that is the first document. Now at the bottom, again, there's a place to sign it. You have to sign. So if someone's going to file a lawsuit, they have to sign it. If you don't sign it, it's no good. But you have to sign it, date it, and then the tenant's going to put their phone number and their address down there. The reason the tenant would do that is just so the court knows where to send things to, like notices, and it could be like a trial notice or a court date. You have to give them your contact information so that they have a way to contact you. And if your address changes during the course of the lawsuit, you need to contact the court and let them know that. Or better even yet, file a form, write something like a notice of address change and put your new address in there and put it in the court file. All right, so that wraps up the first form. The only other thing I wanted to show you for this first part of this training is we're going to look at a couple of worksheets that we Legal Aid has created that can help people get organized when they are going to actually have the trial date. So this worksheet is just giving some info on what the person needs to get ready for court. Typically the tenant wants to have everything in paper copy. Most judges will not allow you to show stuff on your phone to the judge. It has to be printed out, so that needs to be hard copy. And the tenant usually wants to bring 3 copies of everything that they want to show to the judge. And so the first part is for code inspection reports. If there was a code inspection, you want to write down the date it was issued, the date the landlord was ordered to fix it by the city or the county, check whether or not the landlord has fixed the problems or not, and then list the ones that the landlord hasn't fixed. So again, this thing is not something that the tenant would file. It's just a piece of paper the tenant can keep to help the tenant get organized for the case. Normally the person who wrote the report. So if you want to show the report to the judge, you may want to try to get the code inspector into court. But to do that, you'd have to get the clerk to issue a subpoena to the code inspector, and that's something that the tenant could ask the clerk of court about. If the tenant cannot get the code inspector in there, but still wants to put the report in, there is an exception to the general rule. The general rule being that whoever wrote the report needs to be in court if you want to show it to the judge. But there's an exception to that general rule, Rule 803(8), and that's a public record exception. So that's just a note there. Like if the tenant's trying the case and tries to get the report in, but they can't get the code inspector into court and the other side objects, the tenant could point out that rule and say, well, because this is a public record, the court should still take it. This is talking about the specific issues that were a problem. So if the tenant is testifying and showing pictures and documents and whatever else they have about the bad conditions at the home, they need to go through each bad condition one at a time. So maybe there was leaky pipes and there was an infestation of rodents or something like that. The best way to stay organized is to address each of those issues one by one. And this just kind of helps lay that out. First of all, what was the problem? When did the problem start? When did the tenant first tell the problem to the landlord or give the landlord notice? And then how did the tenant do that? Phone, email, text, etc. Did the landlord attempt to make any repairs on the property? And if the condition is still a problem, why is that the case, right? So these are just some things that the tenant can go through to try to help, again, stay organized. And there's places on here, so it just repeats itself, right? So for each problem or each bad condition, this worksheet gives you space to kind of take some notes on that to help stay organized for the trial. So that's that worksheet. The second worksheet, B, this is talking about out-of-pocket expenses. So if the tenant did have out-of-pocket expenses, this gives some examples of that. Sometimes if the problem causes the tenant's property to get damaged, like maybe you have mold in the property that the landlord won't remediate, and you end up having property damage because of that, this gives space to take notes on that. So what was the first thing that got damaged? What was it destroyed or damaged by? And then how much do you think that item was worth? Now for property that's been lost, you can't really ask the court for the cost to replace the item, but you can ask for compensation for how much the item was actually worth at the time it was destroyed. So if I bought a brand new TV and it cost $500 when I bought it, 4 years later, if that TV gets destroyed, let's say because of bad wiring at the house, I can't ask for the cost of a brand new TV because the TV wasn't new when it was destroyed, right? So you want to think more of like yard sale value, or if you were trying to sell the item on like Craigslist or something like that, for example, that's what you can ask the court to compensate for. So then, yeah, there's places for several of those items to be listed if the tenant had any property that was destroyed. And then this is another section here this is not property that was destroyed. This is stuff the tenant had to buy because of the landlord's failure to make repairs. So for example, if there was no working furnace during the winter time and the tenant was freezing and the tenant complained about it, the landlord wouldn't fix it. And so the tenant had to go buy a $200 space heater, right? That's the place to list that. So you list what the item was, how much it cost. And so, and the same thing. So you would list all the items here that you had to buy, and then like what the total amount was for how much that costs. And then when we look at this part, maybe the tenant paid somebody to make repairs, or they had to, do the repairs themselves. They can write that down here, and then how much it costs the tenant to make those repairs. Sometimes the conditions are so bad the tenant may have had to stay in a hotel until they were fixed. And so that's a place where the tenant can list that information, talk about how long they stayed in the hotel and how much it costs for them to do that. Another common situation is increased utility bills. So if a tenant has something, let's go back to the leaky pipe example. Let's say before the pipe started leaking, the tenant's water bill was usually about $100 a month. But then after the pipe started leaking, and the tenant told the landlord and the landlord didn't do anything about it, the water bill went up to $150 a month. So, excuse me. So this is a problem this is a place to record that information. So, whatever the utility is, my water utility bill, for example, has increased significantly since, you put the date, you write down what the problem was that occurred, and the landlord failed to make repairs after receiving notice. Then you put down the reason why you think the problem caused the increased utility bill. So in that example, we think the water bill is higher because the pipes were leaking all the time. And then the increased utility bills have cost me this much more than I would normally have paid. So if your bill went from 100 to 150, then it would be $50 more a month than what you normally would pay. And then this is just an other category. So it says I had the following other expense because of the failure to make repairs. So if it's something that was not covered by any of those other things, you could write that in there. So again, I want to emphasize the first form, this one, the complaint for money owed, that's the one that would be filed with the court. These other two worksheets that we went over, worksheet A and B, again, those are not things that would be filed with the court. Those are just something to help the tenant get ready for court and to organize themselves. And so I did want to end on saying too, as far as if a tenant is going to court and if they find out that they are going to be representing themselves on a claim like this, there is some research and some more information that may be helpful for the tenant to know. There's a guide for how to represent yourself in small claims court, for example. There's an eviction defense manual and some other materials online. The eviction defense manual really goes into a lot more detail about this claim, about this implied warranty claim, or the failure to make repairs, and gives like really detailed examples on that. All of this information is available on Legal Aid's public website, which is www.legalaidnc.org. And so I think it's a good idea if a tenant's going to pursue something like this, if they decide to do that, that they look through those materials and try to familiarize themselves as much as possible with these issues. The other thing that may be a good idea for a tenant that's representing himself or herself in court and has never done that before is to go to court one day and just go watch other trials taking place. So courts are public, so anybody is allowed to go into a courtroom and watch what's going on. Even if you don't have a case in there, it's fine for you to go in there and watch. So the tenant may think about talking to the clerk and asking where the eviction trials are held, or where the landlord tenant trials are held, or maybe even where the just where the small claims trials are on a day before their actual court day, and just go in there and sit and just watch, like listen how people talk to the judge and how the judge talks to people. And it may make it easier once that the person's actual court date comes around, because they'll probably feel more comfortable on that. So I hope that information is helpful. Again, in recap, this is a situation where these forms are for a situation where the tenant, where no lawsuit is pending, the landlord has not already sued the tenant. The tenant is the one that's taking the first step, and the tenant wants to file a lawsuit affirmatively against the landlord. The second part of this video, we're going to go through a couple of other forms, including a summons and something called an indigency petition. And both of those are really critical documents that would need to be filed with this form as well. The indigency petition is really important too, because if you qualify as indigent, you can get the filing fee waived to file this complaint. So I hope that information was useful, and stick around for the second part of the video, and we'll go through that other information as well. Thank you so much.